Hello everybody, my name is Reinier Smit. I'm an intellectual property attorney at Summa PLLC located in Matthews, North Carolina. I recently went to a trade show called Cultivate 21 located in Columbus, Ohio. It was presented by American Hortica and it showcased some of the most beautiful and innovative species and containers in the horticulture industry. Today I'm going to be discussing a few topics which can help you increase the value in your plant protection. One of the most frequent strategies used to increase protection is the use of multiple types of plant protection. Now, what does this mean? Plant patents only protect against others asexually reproducing your plant. In contrast, the Plant Variety Protections Act does protect sexually and asexually reproduced plants. So what does this mean? If you have a plant patent, you can only stop others from asexually reproducing your plants. You cannot stop others from breeding new varieties with your plants. This is where the PVP comes in. One frequent strategy is to overlap or get both types of protection. Often, depending on the type of situation you're in, you are either dealing with growers, retailers, or a combination of both. In a situation where you're dealing with growers, it may be more beneficial to have the PVP protection. Remember, the PVP protects against infringers that sexually and asexually reproduce your plants. Now, a retailer, for example, maybe all they need is that plant protection patent. They are not breeding plants at their facility, they are simply selling them at a retail cost. There, a plant patent is all you need. If you're ever in a situation where you're dealing with both growers and retailers, that is a situation where it may be beneficial to have both the plant patent protection as well as the PVP. One other technique that breeders typically use to increase the value of their plant protection is the use of trademark. Now, trademarking is a source identifier. So what that means is you typically cannot get a trademark on something that is what they call descriptive. Now, one clever technique that breeders use is that they brand their variety with a different, unique name compared to their varietal name. Everybody knows Honeycrisp as the apple. Now, it is actually the variety. They are unable to get a trademark on that, therefore anybody can use the word Honeycrisp in relation to apples or fruit. Now, in contrast, apples such as Macintosh, Pink Lady, Red Gala, those are all trademark names. Most consumers don't realize this. However, those names are separate and unique from the varietal name. This allows, in a sense, you to have protection beyond the 20 years of issuance typically given in plant rights. Again, plant patents are 20 years from filing, and PVP rights last 20 years from issuance. Now, trademarks last for an indefinite period of time. As long as you're using the mark in commerce, you can continue to have the exclusive right to that name in your goods and services. So you can see that even once the patent protection fades, you still may have the trademark to name your brand. So while they may not know your varietal name, they will remember your branded name.